Good evening, Professor Dillard. My name is Cortina Duck. Court is now in session, and today I will be going over the use of hearsay in the courtroom. What is hearsay? Hearsay is a type of testimony that is generally prohibited in court as testimony. However, there are some exceptions to that rule, though. Hearsay usually involves someone testifying about what someone else said or wrote. The definition of hearsay is an out of court statement offered for the truth of the matter asserted. It is the job of the judge or the jury in a court proceeding to determine whether or not the testimony is credible in the proceeds of that trial. Hearsay may come in many forms, written or oral statements, to include gestures, for example. A head nod is a silent assertion of the word yes, for instance. So, an out of court statement is a statement that is being made by a person during a trial that has not been sworn in. You must be sworn in and swear to tell the entire truth and nothing but the truth. Hearsay is usually excluded in court cases because it's deemed an unreliable source. It's unreliable in the sense that during the testimony, you cannot verify it during a cross-examination by the purporting person because they don't have direct knowledge of it. Rejecting hearsay information furthers the goal of the judicial system to not convict or set free people based on mistaken information. Rejecting hearsay information furthers the goal of our judicial system to not convict or set free people based on mistaken information. There are two main articles when it comes to having exceptions to the hearsay rule. The first one is when the declarant is unavailable, and the second one is when the availability of the declarant does not matter. When the declarant is unavailable, the statement that would only incriminate that witness, so it is said so to be reasonably assumed that that statement is true, or the witness would not have said it. That previous statement was a declaration against interest. A dying declaration would be a person's last words before dying, maybe admitting some truth, and it would be held credible in some cases. Now I'm going to try and sum up for you in my head what I retained of what the use of hearsay is in court. Okay, so I'm going to give this a try and see if I do it correctly. So let's say we have two women. Michelle and Mary meet on the street. Michelle tells Mary that she saw Elizabeth going into the bank early in the morning, for instance. That statement made by Michelle would become our out of court testimony statement. Now, so Michelle saying that she saw Elizabeth going to the bank later on down the line. Now, what if Elizabeth is put on trial for stealing from the bank? The prosecutor is going to want to prove that Elizabeth stole from this bank. So, can he ask Mary, the person who Michelle was originally talking to testify that Michelle saw Elizabeth go into the bank? Would that be credible? I don't think it would be, because it's hearsay, because it was deemed the out of court statement that was made by Michelle originally, and it wouldn't be able to hold up as truthful because neither one of the parties were sworn in. I hope that was pretty sufficient as far as breaking down what hearsay is in the courtroom setting. I will also offer another example via video on YouTube. Have a great evening.